Important rules as a judge, always pick up your robes so you don't trip over. The matter before the court is Aroostook County 23352, State of Maine versus Christine Desrosiers. Counsel appear to be present. The matter is being streamed live on the web. If counsel would introduce themselves by saying their names for the record, together with the party you represent, starting with the appellant.
Mark Perry, attorney for Christine Desrosiers. Matthew Hunter, representing the state of Maine.
Thank you. Then, Mr. Perry, if you're ready to proceed, we'd be happy to hear your argument.
Thank you very much. May it please the court, counsel, I'm excited to be here today because a well-written ruling in this case can reduce dramatically the number of people sitting in jail without lawyers. The charge of failure to submit to arrest is very often tacked on to other cases. If you listen to the radio and hear charges described, it'll always be the last one that they mention. In major cases, that makes little difference. The case will fall either way on the more serious charges. But on the minimal offenses like this one, unregistered motor vehicle, illegal attachment of plates, 30 over speeding, eluding, operating after suspension, the addition of that charge of failure to submit to arrest, that bumps it up from a fine-only case to a jail case, which means they have to have a court-appointed lawyer, and bail often gets set to where they can't meet it. So they end up sitting in jail, sometimes for months, because we have a rule that the prosecutors can't talk to the unrepresented defendants. So they sit there without counsel for often a long period of time. And for the benefit of the folks listening here, I'll set the scene a little bit. Christine Desrosiers, her elderly mother and grandmother, moved from Florida to a cabin a mile off Route 11 in Masardis without power or running water. And Masardis is on Route 11, halfway between nowhere and nowhere still. And they did that because the fairest thing to say is that they're just allergic to law enforcement. They just wanted to be away and be left alone. In fact, when this stop is made, the very first thing Christine says is, "Leave me alone." That's their mindset. Even though they made great lengths to be out of society and alone, they had to come into town for supplies. So they came into the Save-A-Lot to get groceries. Officer White noticed the missing inspection sticker, which is the most minimal offense there is. In fact, half the states don't even have vehicle inspections, but he pulled in behind them because of that. He noticed that the plates were registered to Derek Richards. The Desrosiers family was buying the vehicle from Richards, but they hadn't got the title yet. The only evidence in the record as to when the title was transferred was that it was done in mid-June when Richards' widow found him. In other words, found the title. And Maine law is very clear. In fact, it's crystal clear, black and white, that ownership of a vehicle does not change until the title is transferred. So that vehicle was legally owned by Derek Richards until mid-June when the title was passed. They were using it with the permission of Mrs. Richards, so they were not operating an unregistered motor vehicle. However, Christine was uncooperative, so Officer White decided to effect an arrest.
Counsel, the green light is on, which means you're fair game. Going to this last point on the unregistered vehicle, the only evidence, it seems, here of her obligation to register was her own words that she was the owner of the vehicle. Is that your view in this case? I mean, she did say when the officer asked that she owned the vehicle.
She said, "We bought it a couple weeks ago." But that's in the sense of
Well, I understand it can be explained and it may not, but isn't that in and of itself, the fact that she did say that, is that enough to convict her beyond a reasonable doubt of failure to register?
I don't believe so, because the ownership does not legally transfer until the title is transferred.
And so does the state have to prove that she, I mean, do they have to show something other than her, I mean, if I said, yeah, that's my car, isn't that enough?
I would say the officer needs to ask one more question. Have you got the title yet?
Okay. And then turning to the refusal to submit. Is the question the physical force? Or is it, what does it mean to say physical force against a law enforcement officer?
The statute specifically says physical force against a law enforcement officer. That is what is required.
So what does that mean?
Wonderfully, that is what you are going to decide. Because what frequently happens is the officer says, you're under arrest, get out of the car, and they lock the doors and get on the phone to dad. And that is charged now as refusal to submit to arrest. Here, what was done was simply going limp, dropping to the floor. The two officers described that in the report as passive resistance. And on redirect, the DA valiantly tried to get one of the officers to come up with any use of force, and the only force he could identify was gravity. Gravity was the only force used here. There's lots of things. Of course, you have to look back at the 2009 attempt to make it criminal to offer any resistance whatsoever. There was a proposal to do that, and the legislature consciously decided not to make those lesser interferences criminal.
In this instance here, there is a video of this entire event. I mean, it went on for quite a while.
Yes.
Correct? And you don't dispute that your client was very agitated. She was screaming and yelling and using language with the officer that indicated that she was not going to cooperate in any way.
Free speech, yes.
She did that with her First Amendment rights. She also used a fair amount of body language, like turning her back on him, and maybe that's nonverbal language there. But at a certain point, when they're trying to effect the arrest, her refusal to cooperate to the point where they have to lay hands on her, to handcuff her, and her falling to the ground, it does require that the police respond with a physical element, because the resistance is also physical. Does that not lap over into the use of force against the law enforcement officer?
You have to look at the 2009, what the language in 2009 would have prohibited.
Yeah, I saw, and just to be clear, so everybody's on the same page, the legislature at one point in the statute did have language that would catch this, basically being uncooperative with a police officer. Law enforcement liked that because they run into that, sadly, frequently. But the legislature said, no, because that would sweep up people who are demonstrating, political demonstration. People who sit there and say, I'm not going to get up, and the police have to cart them away. And that was also an exercise of free speech. So you're correct, the legislature didn't endorse that. But looking at the four corners of what was happening here, the use of her body in a way that required the police to interact with her physically, that doesn't squeak over into her use of physicality against what the officers are doing?
That's exactly what you do at a die-in. When I was a kid, we were protesting the Vietnam War, and people would go and lie down as if they were dead all around, and the officers would have to come over and pick them up and carry them. That's exactly with the passive resistance that the criminal...
But counsel, excuse me, this was more than just lying passively on the ground. She was struggling, she was resisting. When they put her in the vehicle, she extended her foot toward the officer. When they buckled her into the back seat, she unbuckled that. At what point does the arrest occur here? And are any of her actions in the back seat of the car resisting getting into the back seat of the car and directing some of that outwardly? Does that, at what point does the arrest occur?
I believe the arrest occurred when she was handcuffed and placed in the vehicle. In that event, she's in confined now. She's in a cage. They call it the cage. She's in the cage. But those other activities of requiring them to pick her up, requiring them to lug her, that could only be that lesser interference that was specifically considered by the legislature and not adopted in 2009. If you don't, she didn't kick anybody. She didn't hit anybody, an officer. She didn't kick. She didn't bite.
Well, if she had, that would have been an assault. That's a different.
True.
That's a different
True.
charge.
But that's what's required under the use of force against an officer, not a cruiser,
Can,
Use
can
of
we, can we
force
just
against an
test,
officer.
can we test your thesis here? Hypothetical. Officer says to an individual, you're under arrest, and he wants to handcuff them. He gets the handcuffs out, and the individual being arrested pushes the officer's hand with the handcuffs away. Does that cross the line?
Well-
I'm taking your thesis to see where we draw the line.
If you use force against an officer, whether it's an officer's hands, an officer's back, you kick an officer, I would say that qualifies as use of force against an officer.
So that would be, okay, now one step further. He's trying to handcuff the person, and the person simply folds his arms under his underarms.
That's perfectly okay.
Okay, all
That's
right.
perfectly.
All right,
Running away, now the funny thing about running away is that we have a separate statute that says you're a criminal if you don't stop when told to. So you can run, and if he takes a minute to get out of the cruiser and then can't see where you are, you're fine. That's not an offense. They could have made it offense, but they chose not to. This statute requires the use of force against an officer, not the officer's cruiser. And if we can get this pinned
But it
down-
doesn't say how much force. So there's being limp, which is no force whatsoever. But if you use any force to resist the arrest, does that fit in with the literal language of the statute?
It doesn't say, and as I said, that first paragraph that was going to be enacted in 2009 would have addressed any force against anything, any effort to resist. But they limited it to force against an officer. So it has to be hitting, punching, kicking, grabbing, something against an officer, something voluntary against an
So
officer.
extending the hypothetical to the extent that the person the police are attempting to detain or arrest folds their arms so they can't be handcuffed, and then as the officer attempts to handcuff them, has to rest their arms, pull the arms towards the officer in order to get the cuffs on them. Is that force against the officer to the extent that there's resistance?
The way, where I would draw the line is that if it's force toward myself, it's not force against an officer. Now, you folks get to draw the line. I would say if you get the handcuffs on and you push at the officer's chest, that's force against an officer. I would say that if you pull away, it's force away from the officer, not against. But that's just me. You guys are going to get to draw this line, and I really appreciate it. There's no main case on this, and officers are charging this every single day on almost every encounter. People refuse to get out of the car. Just get out of the car. No.
We get to view the record in this case, which includes the video clips that were shown to the jury.
Yes.
What is our ability to discern whether or not the fact finder could determine that there's no way the jury could have found beyond a reasonable doubt that there was a violation of the statute in this circumstance? There's
nothing, I viewed it myself, obviously. She is shown being picked up and taken to the cruiser, but there's never a punch thrown, there's never a kick. And of course, in opening statement, I was worried that something like that was going to come out, but it never did. There was never a punch thrown, a kick, anything, any force used against an officer. And
Well, they had to tase her at one point, correct? Dry
they
tase
tased her 3 times
Okay.
because of her, once she was in the cage, they tased her 3 times because of her tantrum. She's, by background, she's had PTSD because of being raped by a man in uniform years ago, and the whole family has been a very, very sad history that they were trying to escape from by getting into this cabin in Masardis.
Thank you, counsel. I see your time is up. Mr. Hunter?
Excuse me, may it please the court. I'd just like to touch on some of the issues sort of in reverse order, addressing I think the least interesting ones first. In the state of Maine, you can't operate a motor vehicle unless it's registered. It needs to be registered by the owner. Officer White, who was the primary investigator, testified that during the early moments of his interactions with Ms. Desrosiers, she told him that the decedent sold her the vehicle. That would support a finding that she was the owner. Those statements were contained in the video that was shown to the jury, The evidence supporting the operating an unregistered motor vehicle was sufficient because the evidence in count 2 was sufficient, the evidence in count 3 was sufficient. With respect to the refusal to submit to arrest offense, it's physical force, not physical contact. And then I think the term that this court's got to identify is against. The ordinary meaning of the word against is in opposition to. So you're talking about physical force in opposition to the officer's efforts to arrest or detain this defendant. And obviously, the court's reference, you've seen a video that depicted almost the entirety of this event. There's the moments when the cuffs are being put on, and she's led to the car, and then she's strapped in. And then there's the portion of the video where she's in the car and she's concealed. She's in the detention phase at that point. She's using physical force. She's using it in opposition to the officer's efforts to detain her. There was an issue about the admissibility of the second clip of the video. And at trial, they talked about relevance and prejudice. It's also evidence of the crime being committed. The crime was still being committed while she was in the car during the second event, while she's somewhat flailing around.
You're saying that once she's already essentially been arrested, been restrained, put in the car, that what she's doing at that point is still relevant to the whether she's resisting arrest?
The offense is refusal to submit to arrest or detention.
Correct.
And I think when we hear detention, a lot of us, knee-jerk reaction is Terry stop. But the arrest, there's an arrest, and then the detention is what happens between the formal arrest being effected and either a bail commissioner bailing this person or them being transported to the custody of the
But
sheriff.
isn't the problem at that point that to the extent she's doing things like kicking or struggling in the back of the car, she's still, even if that's physical force, it's not against the officer, it's against the car?
If you don't interpret against to imply physical contact, it's in opposition to the officer's efforts to detain her, with the intent to make that
Well,
detention more difficult.
But with all due respect, counsel, when it talks about intent to hinder, delay, or prevent,
Yes.
okay, but it also says then uses physical force.
Yes.
And it's not just uses physical force with an intent to hinder, delay, or prevent. It's using physical force against an officer. I mean, we can't ignore that language.
If it meant physical contact,
Wouldn't any officer, I guess what I'm saying is, by definition, it starts off with the intent to hinder, delay, or prevent a law enforcement officer. It would be surplusage if you start saying that the against doesn't mean it has to be physically against the officer.
I guess I didn't follow that last point.
Well, it feels like you want to just say as long as she's intending to hinder, delay, or prevent the law enforcement officer from effecting the arrest or detention,
Yep,
and at some point uses physical force,
yep.
that because she's preventing them, you're saying in use in opposition, isn't that covered already by the intent to hinder, delay, or prevent?
Well, she could intend to hinder, delay, or prevent by what she says.
Well, and you're saying anything that's physical,
Physical force, yes.
yes.
But you've tacked on some language to subsection B. It says, uses physical force against a law enforcement officer, period. But you're reading it, uses physical force against a law enforcement officer who's trying to arrest somebody. In other words, uses a physical force against the police officer's efforts, which is fundamentally different than physical force directly against the officer. So when I think the words are ambiguous, we need to construe them. But I have to say, when I first read it, the interpretation you're serving up here didn't even occur to me. I just read, uses physical force against the law enforcement officer. That seems to me to mean physical force against the person of the officer, not against the officer's attempts to arrest her. Do you follow what I'm saying there?
I do, but I think the ordinary meaning of the word against is in opposition to.
Another ordinary meaning would be physically against somebody. I mean, you could use physical force against somebody without necessarily intending to oppose them. You want to weave in the fact that the officer is trying to arrest her, and she doesn't want that to happen. But she could do that without using physical force.
Yes.
But this one here tees in physical force. And I have to say again, against the law enforcement officer, just rings in my head, meaning physically against the officer.
If I could recast it this way, looking at the structure of the statute,
Yep.
the opposition in opposition to, why isn't that really subsumed in the very first paragraph? Because that's the whole point of refusing to submit to arrest or detention by hindering, delay, or preventing a law enforcement officer from effecting the arrest. And then there's three different ways that could happen. One is refusing to stop, creating a risk of injury, or using physical force against the law enforcement officer.
Right. Why isn't it subsumed by the first part?
Yeah.
I think it refines the way you could use physical force. I think in the earlier questions, some of the justices noted the physical force could be just about anything, right? How much physical force are we actually talking about? So if you were to refine it to only that physical force that appears directed in opposition to what the law enforcement officers are attempting to do, that would at least refine it and narrow it to some extent.
How does the use of gravity, though, how does allowing gravity to operate constitute a use of force?
So that officer, call it Kyle, Officer White, so he said that. The jury wasn't bound by his characterization, but I think what he meant was, or what he should have meant, was when she lifted up her legs, that was a use of force, and then gravity took over from there.
So, go ahead.
Did she lift her legs against the officer, unquote?
Her feet were planted on the ground, and in order to, fall, she, I don't know that she necessarily lifted them 6 inches or anything, but that was the physical force, was what she did with her legs to cause the gravity to take over, to cause the arrest or the detention to become more difficult.
Well,
Just
if
to be
she's
clear,
laying on the ground,
What's that?
if she's lying on the ground
Yep.
and refuses to get up, the officer comes along to arrest her, but she's not assisting in getting up. She's in opposition to being picked up and put into detention. Does that meet your definition of?
I think if she was truly passive, I think that would be hard to do. But if you could do it, if you had the discipline to remain truly passive while somebody was attempting to lift you up, so that your body isn't exerting any force in any particular way, then it wouldn't meet the definition.
Well, lifting up the feet and then having gravity take over because there's no support, in your mind,
Yep.
is force being utilized in opposition to being detained or arrested.
I think it is, especially when you figure that she knew what would happen when she I don't know if she lifted her legs or let her legs go limp, but she knew that it would cause her to become more difficult to arrest when she did that.
Just to be clear, the
And that
jury
was-
saw this video?
Yes. Yes,
and-
they did.
And the jury, based on seeing the video and being instructed, found physical force against an officer?
Yes.
Let me just,
Under the statute, the jury has to find that she intended to hinder or prevent the officer from making the arrest, correct?
Yes.
That's part of the elements. And so therefore, doesn't the phrase against have to add something else? And I'll tell you, counsel, I went down a little rabbit hole in preparation, and that phrase is used in the Armed Criminal Act in federal law, and there's actually a lot of federal cases talking about what that phrase means.
Against?
Physical force against. And as the First Circuit said, that the canon against surplusage does at least suggest that the follow-on phrase against must be conveying something the phrase use of physical force by itself does not. And in fact, that they find that it means a specific intent to actually use force, in addition to the intent to hinder.
And then to use force against or in, I believe it means in opposition to.
I understand that that's what you think it means.
I would like to understand the interplay between B and C, because C has created a substantial risk of bodily injury to the law enforcement officer. And B is, use of physical force against the law enforcement officer. So when do you have, and they're both the same class of crime. So so what's the difference? Why is substantial risk, what are the circumstances where that happens versus the circumstances where B happens? You're saying it's less. It's practically nothing, and it's the same level of crime as substantial risk.
I don't know that I've seen that charged very often. I haven't given that a lot of thought. I don't know. It
Well,
could
we're
bear,
supposed to read this as a whole and
It
try to
could-
make sense of it.
How about a high-speed chase?
well, it could all bear on the extent to which this person is frustrating the public administration. It falls within that chapter.
Well, subsection C doesn't require that they actually make contact with the officer, just do something that creates a risk. Dropping a weight in front of the officer in a chase or a high-speed chase, that might loop that in. But I want to take you back to the definition of force here. You said, she raised her feet off the ground and it caused her to fall down. I think probably what really happened is she just let her legs go limp and she fell to the
It
ground.
definitely could be.
So it's the opposite of force. She is relaxing her legs to fall. I don't want to make it too fine a point on it, but I don't think she used force on her legs to make herself fall, and therefore it was harder to arrest her.
Well,
Where's the beef? Where's the force?
yeah, I don't know if she just let her legs go limp or if they picked up. When I watched the video, I wanted to see her legs because it almost looked like she was kicking back, but nobody said she was kicking back. But I think manipulating her legs or using her legs, whether they're contracting or just going limp, I think that could be force, and especially so because you can anticipate the effect that gravity is going to have on the rest of her body.
But you're
when she
still
does
left
it.
with the problem of whether it's force being used against an officer.
When I watched that video, it looked like her body caused those officers holding her by the arm to struggle more, but sort of go down with her. I mean, she didn't overwhelm these folks. It wasn't effective use of force. But you can see how it affected their performance of that arrest.
Can I go to the other charge, the failure to register a motor vehicle?
Yes.
Do you agree that the only evidence you had that she might be guilty of this offense was her own statement that she had bought the vehicle and was the owner of the vehicle, correct?
She said it twice.
Her
Yes.
statement that she bought the vehicle was the owner of the vehicle. She
Yes.
said it twice in the same span of a very short
Yeah,
period of time.
6 minutes, yeah.
All right. The jury wasn't given any rubric to decide whether she was, in fact, legally required to register this vehicle. In other words, all the judge did was give them the language of the statute. The defendant raised an issue about when it's a transfer from a deceased person, at what point she actually had the obligation to register versus someone else. How can we let the jury just say, well, she said she was the owner, that's good enough? When they weren't given a rubric, when they were given that information, that the person who had owned it was deceased and they were in the process of buying it. They were never told, how do we decide when, at what point, or under what circumstances she is the one that has the obligation to register that vehicle?
Well, there was conflicting evidence about whether they were in the process of buying it or whether they'd already bought it. In the moment when she was arrested, she said he had sold it to her. And then there's a counter-narrative at trial where that was a slower process.
Well, she told the officer that she'd bought the vehicle, in fact, that she was the owner. Then during the trial, she said she didn't get the title until later. Should the court have told the jury that a person is the owner of a vehicle for purposes of a requirement to register only if they are able to register, and that's the case only if they have title? I mean, if you believe her account, it would be impossible for her to have registered the vehicle if she didn't have the title. Do you agree?
If you believe her, yes, if you believe her account.
Well, shouldn't the jury have been told that they need to decide whether to believe her first statement that she was the owner or whether to believe the statement that she couldn't register it because she didn't have the title?
I don't think that would make the process worse. I wasn't at the trial, but I can kind of imagine when they were formulating the instruction on that offense, It probably, and it probably wasn't a days-long process. They probably put that together pretty quickly.
Thank you. And Mr. Perry, you reserve some time for rebuttal.
Yes, thank you. This, if this case can come down with a remand for an acquittal or entry of not guilty, it can get published and it can have a big effect. This offense of failure to submit is tacked on to almost every, not almost every, but very, very many minor criminal cases, turning them into pseudo-major cases. And what I've never heard when I hear this discussed on NPR and all these places is what happens in that situation. Instead of it being personal recognizance and a fine-only case, it's now a $500 fine, $500 cash, and a jail offense. The person gets jailed. They can't make they can't raise that fine money. Their vehicle has gotten towed. It's $200 for the tow and $100 for each day. So they lose their vehicle. If they've been homeless, they lost everything that's in the vehicle, their kids' toys and clothing that are in the vehicle. If they are stuck in jail for more than a few days, they lose their job. That means they lose their apartment. Now, Maine law says that when someone's evicted for non-payment of rent, the landlord has to store their things and give them notice. But the notice goes to the apartment address because the landlord has no other address. So,
I understand what your argument is there. Can I return to the registered vehicle? And because the significance of that as well is even if you were to prevail on the failure to submit to arrest, you also, unless you prevail on the failure to register, your client would remain convicted of violation of bail conditions. Do you agree with that?
no, I'm sorry, you posited that if she prevails on the arrest and doesn't prevail on the, then yes, she committed an offense while on
So
release.
it's important. And I guess no instruction, as far as I know, there's no request for instruction to have the jury understand or explain when the obligation, and since I'm the chief, I get to say I'm in the intersection, that when the obligation to register accrues. In other words, although you put on evidence, the jury wasn't instructed as to when she would have the obligation to register herself or not, but no instruction was requested. So is that just waived, that argument? And becomes a matter of fact, the jury could believe she was the owner, therefore that's it?
I don't believe it's waived. It was an imperfect performance on my part. These are very high-strung people. They had a service dog in the courtroom and so forth. And I should have requested a more specific instruction on that, but I do not believe it's waived.
Thank you. Thank you, counsel.
Thank you.
Thank you to both of you for your arguments here this afternoon. As is our usual practice, we will be issuing a written decision in due course on this matter. And with that, I think we are in recess here at the school. We are actually going to be reconvening in our courtroom in Portland this afternoon to hear a couple of more cases. And then tomorrow we're on to Deering High School in Portland, and then on to Lewiston High School the following day. So thank you for your attention here this morning, and we appreciate it.